All right, folks, let's talk about this Heather Locklear case. Dan Schorr is here with me, Managing Director at Kroll, attorney. Good to see you, Dan.
It's great to be here, Aaron.
Okay, so what do you make of this Heather Locklear case? EMT with injuries to the head and neck, and then this is on top of some other legal issues with an alleged attack on, what, her boyfriend earlier?
Right. Well, first of all, if there's any allegation against a celebrity or someone perceived to have deep pockets of hitting someone, that person is going to file a civil suit. That just is par for the course. So whether or not this EMT was actually injured, there's an allegation, there's an arrest, there's going to be a civil suit. That happens to any celebrity. I'm sure you deal with that as a law and crime celebrity, that people are suing you for allegedly doing things all the time.
I blend into the woodwork when I walk out of this place. So, you know, what if the rule, isn't there a tort rule that says that if you're a first responder of some sort that you can't recover, or do I have that backwards?
That you can't recover in a civil suit?
Yeah.
Well, if you're assaulted by another person you're not suing the state, it's not part of the assumption of risk of being an EMT. Like maybe you assume some risk that you might get hurt in the course of your job, but being assaulted by someone else who's a private citizen, you're not assuming any risk there. So I would assume you do have a civil suit there. If it happened, we don't know what actually happened, but certainly I think there's a claim here if she was injured by her.
If we take the facts as true, then that would not bar recovery for this EMT who's apparently injured. I guess this is going to turn on a question of how severe the injuries are. That influences damages.
Right, and a lot of these cases get settled because Heather Locklear, there's the reputational damage to her besides the criminal liability and the civil liability. So in a lot of these celebrity assault cases, you'll see a settlement where there's money paid to the person suing them to make it go away, and that's usually what happens. I'd be surprised if you actually see a trial here, but you never know.
Never know. We're going to have to wait and see how things play out. So we're going to continue our look back at the Frankie Gebhardt case here on the Law and Crime Network. This is a cold murder case that happened in Georgia. The accusation that basically a racist defendant had killed an African-American named Timothy Coggins 30-some years ago. And the reason he did it, according to the state's theory of the case, was because that victim, Timothy Coggins, had expressed some kind of interest in a white woman. And that upended the social situation in this town where this crime occurred. Again, Frankie Gebhardt on trial, accusations from the state that this was a racially motivated killing. Let's continue with our review of testimony. This is Larry Peterson. He's a crime scene analyst on the witness stand. Testimony there from Larry Peterson, a crime scene analyst, talking about the hairs that were recovered from the victim, the crime scene, talking about wounds that the victim suffered. So, Dan, look, this is not directly pointing the finger at the defendant, but it's painting a picture of what happened, that the crime was committed in this fashion, that there was a knife involved, there was not a shooting, and that there were hairs from white individuals related to the crime.
Right, and the brutality of the crime is a big part of the prosecution's case. Even though that doesn't show the defendant committed it, it's certainly a part of what happened here. And it also shows why should the jury care 35 years later, because that is a part of a cold case. Why are you hearing this now? You need to show why it wasn't proven before and why it's important now in 2018. And the brutality of what happened is part of the reason why investigators went back at this, dug up more evidence, and ultimately brought this defendant to trial.
And of course, one of those pieces of evidence was a knife that was recovered from a well, and the accusation is that that might have been the murder weapon and that the defendant threw it in the well along with some other clothing and other articles to try to evade detection.
Right, and one of the major challenges here is that evidence that was collected at the time is missing. So prosecutors, investigators at the time who did not bring charges had evidence from the scene. Some of it went missing, some of it might have been contaminated, and now 35 years later they're trying to find new evidence and also explain what they can find from the current evidence. That's a major challenge. You have an active crime scene that happens now, it's already challenging to process it accurately. Imagine going back 35 years where it sounds like the investigation was haphazard, was not complete, it wasn't maintained and organized in a way that could have been left for posterity to look at it years later, and this is a major obstacle for the prosecution here.
Yeah, we all wish that we had that hair to collect DNA from, the Caucasian hair that witness was just discussing. But more testimony now from Larry Peterson, the crime scene analyst. He's getting into some issues with blood on the evidence and, of course, the wish that more had been retained. And there we have the crime scene analyst Larry Peterson talking about the wish that more of the evidence had been preserved in the Timothy Coggins murder case. Dan, that's the wish we all have, because it would make this a lot easier and require fewer mental gymnastics to arrive at a result.
Right, and it's consistent with what happened 35 years ago that law enforcement didn't seem to really take this seriously. So not only was it not fully investigated as we wish it was, also the evidence that was collected doesn't seem to have been preserved. And maybe that was intentional, maybe that wasn't, but that makes it very tough for prosecutors, investigators to prove a case beyond a reasonable doubt, because the defense can always point to the absence of certain evidence or the removal of evidence as a problem with wanting to convict their client.
And it was an interesting case because the state basically said, hey, look, we screwed this case up at the beginning, but there were new people in charge there. And they asked the jury to buy that argument, that they were trying to make amends for a past bad investigation. We're going to take a break here on the Law and Crime Network and be back with more testimony in the Timothy Coggins case when we come back. Folks, that was a police interrogation with Frankie Gebhardt, the defendant. He starts flailing in that interview and basically just says, yeah, I deny telling people that I was involved in this murder of Timothy Coggins, an African-American man who the state believes was killed because he was interested in socializing with or a relationship with a white woman. And look, police were starting to narrow in on this defendant and ask him what's going on, and he started flailing there. So Dan Schorr, managing director at Kroll, you're an attorney. What do you make of this interview? This is unlike interviews that we normally see.
It's a strange interview. I mean, they're coming right at him with the accusation and letting him confirm or deny it. I think maybe a slower approach to bring him in, try to get his trust a little more, although we're not hearing everything there.
Yeah, I mean, this went on for a little
I know,
or something like that. So we were keying in on the key
right.
stuff.
It's just still strange how direct they're being at that moment. But the couple things jumped out at me. One is he's being accused of a racially motivated, heinous murder, and he's accused of confessing to other people using the N-word. And in that police interrogation video, he says, I never killed, I believe that, and he uses the N-word there. Now, if you're being accused of a racially motivated murder, you think you would steer away from using that word when you're denying the murder, but he doesn't even have that sense to appear as a non-racist. He's just using racist language as he's denying this racist killing. So it seems like he's not doing a very good job of making himself seem of good character.
That doesn't bode very well for him, but, you know, I mean, he apparently had made some other comments that, well, they need to prove this beyond a reasonable doubt, and they don't have enough on me.
Yeah, he says language to the effect of, well, at one point, I don't really remember if I denied or if I said I killed someone or denied killing that person. I mean, we remember if we confess to a murder or not. So all of his language is very strange here. Now, that doesn't mean he committed the murder, but it certainly isn't helping his case by using racist language and being strange about verbalizing his denial.
You know, it's not smoking gun evidence, but it's another piece of evidence. It's another feather in the cap of the state.
Right, because look, there's a racial motivation for this murder according to the prosecution. So whoever has a racially motivated murder would be a racist, and he is confirming that he is using racist language. So does that mean he did the murder part of it? Not necessarily, but it certainly confirms part of the motivation of the murder that the prosecution is trying to prove.
Yeah, we want to listen now to some testimony from a Captain Mike Morris. This was cross-examination where they try to get into a little bit more about what was going on in that interrogation. This is a key description of what was really going on, the mood in that room. Let's listen. There's the common thread of the defense popping up in that cross-examination of one of the detectives involved in that interrogation. So, Dan, look, here we have the defense saying this guy had a sixth grade education, the defendant. He was drunk for 23 years. That was a piece at the tail end. And that he wasn't confessing to the murder. He was just talking about it.
Right. Supposedly it's not a confession. He's just talking about it. And again, these are all consistent with someone who committed this murder. Does it prove it by itself? No. But that and other evidence, and you have to weigh the credibility of the people who say that they heard the confession to see, are they telling the truth? But certainly it looks bad for the defendant. He's using racist language. He's not really denying it in a very explicit way, the way you or I would if we were accused of a murder. So all of that doesn't go well for the defendant. I don't think they can blame that just on education. Well,
we're going to continue listening to some more testimony from the detective who was involved in that interrogation when we come back here on the Law and Crime Network in the Frankie Gebhardt case. It's a cold murder case from Georgia. More of the interrogation of the defendant, Frankie Gebhardt, on accusations that he committed a racially motivated murder back in 1983 that took forever, basically, for prosecutors in Georgia to bring to trial. The reason, prosecutors admitted, is because the investigation back then had been botched, perhaps because the local investigators were also biased against African Americans. It was an interesting case. We're taking a look back at it today. Dan Schorr is here with me. And Dan, look, we saw some of the investigative techniques in that last clip where, you know, a reference to the defendant's DNA, which of course they didn't have, but they wanted him to think that he did, is how I listened to that.
Right. Also, evidence that had been lost, they didn't tell the defendant that they lost the evidence. So when they were saying, yes, this hair was found, and they didn't mention to him, oh, by the way, and we lost that over the last 35 years. So he, maybe he'll be thinking, you still have it, and change the story.
Yeah, okay, we're going to continue to listen to a little bit more of that interrogation. Captain Mike Morris on the stand, and in that last clip, he was saying that, look, I've got some DNA from this crime scene, and interestingly enough, the defendant, Frankie Gebhardt, is saying, well, you can take any number of my hairs and test them, do whatever you want. So he wasn't really trying to stonewall the investigation, and defense attorneys really honed in on that in closing arguments, saying, look, our guy had nothing to hide because he wasn't involved. That was one of the defense tactics here. Let's continue with our review of testimony from Captain Mike Morris, who was in that interrogation. More back and forth there between the defense for Frankie Gebhardt, who's accused of murdering an African-American man named Timothy Coggins, and the interrogator who interrogated the defendant. So, Dan, we heard there some questions about this interrogation being driven by information learned from a criminal informant. And the defense is basically saying, hey, look, you were just trying to feed him this story that this other guy, who may have been the real killer, was telling you, and maybe that's why he was flipping out, because he knew nothing about it.
Right, and there's two challenges for the prosecution here. One is that the people who were supposedly receiving these confessions are not great people either, but that is kind of the nature of these kinds of confessions. If someone is making this brutal racist murder, who are they going to confess it to?
People who they think are friendly.
Right, exactly. And maybe that's people who are also criminals, people who also have a shady past. And then two, the problem is the timeliness. Why did it take so long for these people to come forward? Why didn't they come forward right away? But you could really understand plausible explanations for why they wouldn't come forward right away 35 years ago. Maybe they didn't have the motivation to come forward because they didn't care, just like law enforcement didn't seem to care 35 years ago. Maybe they were afraid. Someone just told you they committed a violent murder. Maybe they didn't want to go to the police, especially if they already had their own criminal problems. So there are explanations, but this is certainly something for the defense to raise. It's a big issue for them.
Yeah, and of course, now that people have their own criminal problems, they want to get out of the problems that they found for themselves, and does it not give them motivation to turn around and say, this guy we know, Frankie Gebhardt, had talked to us about playing a role in this case way back then that everybody was talking about.
Right. So, and the fact that more than one person says that he confessed to it is certainly helpful, because it corroborates that he was confessing to this. Because one person, you could say he just wanted to get out from under his own charges, but often real crimes are revealed by people who have their own criminal problems than talking about other people. And it's tough for law enforcement and juries to decide who's telling the truth and who's not. So you have to look at the totality of the evidence and make a decision.
What do you make of this claim by the defendant? Well, I was drunk for 23 years. I don't know what I was saying. Drunk for 23 years.
Sometimes people, when they're drunk, tell the truth, right? Sometimes, seriously, when people are drinking a lot, they start to say things that their inhibitions are loosened, and they say things that may be truthful. So just because he was intoxicated, if that is true, doesn't mean that he wasn't accurately confessing to a murder.
Yeah, I thought that was one of the more interesting claims that the defendant came out with here. But we keep going back to just the basic body language, and that detective in the interrogation said, at one point I was afraid that he was going to lunge across the table at me. There was a nonverbal element to this that the tape recorder didn't pick up.
Just hearing the audio, it sounds like this defendant is an intimidating person, because he's being questioned about a murder by police, and he's kind of being aggressive. He's using the N-word, which is obviously racist language, when he's being accused of a racist murder. So he doesn't seem someone who has normal inhibitions to recognize, even if I committed this murder, now I need to pretend I'm this well-adjusted person. He's not even doing that with the police, so that's tough.
Yeah, we're going to continue our review of the Frankie Gebhardt murder case when we come back here on the Law and Crime Network. It was a cold case from Georgia. Can't wait to bring you the next few clips. That was testimony from Charlie Sturgill in the Frankie Gebhardt cold murder case from the Atlanta, Georgia area. This crime happened 30-some years before the trial. Timothy Coggins was the victim. The state said he was stabbed and then dragged behind a vehicle with a chain before his body was left nearly unrecognizably near some power lines in a grassy area. Dan Schorr is here with me to discuss this case. Some of the lines in that testimony from that witness really stuck out. You know, he's saying that Gebhardt said, that's, quote, the most blood I've seen since I cut up that N-word and stabbed him 25 times. So this apparently is the language that's coming out of the defendant's own mouth.
Right, and apparently, according to this witness, he's saying it multiple times in front of multiple people, so it's not just one time he slipped to this one defendant, if you believe this defendant. And I thought it was really interesting how they brought out how at risk this witness is for testifying, because that goes to his motivation to lie. We talked before about, do people who are in jail have an incentive to lie and make it look like someone else confessed to help themselves? Yes, they might, but he's also talking about how he has to go back into the prison population as someone who testified against someone else, and that's not going to look good for him, and he's saying that will endanger his life. So that goes to his credibility to say, hey, I'm not gaining a lot from this, I'm actually risking my life because I want to take this stand.
Yeah, the old line, snitches get stitches, comes to mind here, and you know, that's a real issue, very real issue.
Right. This is being televised, they pointed out. So the people in his prison are going to know he testified. He's going to go back, and he's going to be known as the person who turned and worked for the state. The state is the person, the government, who put all these people in prison. So it's the enemy to a lot of people in prison, and they're going to see him as cooperating. So that's not good for him, and that goes to his credibility to say, look, I'm not doing this just for my own benefits. I'm not really benefiting from it, but I'm doing this because he multiple times confessed to a murder, and I want to talk about it.
Surprises me we didn't get a motion in there to not show that particular witness or something like that, if indeed this danger was as real as this witness wants to make it out to be. Because we get those requests in cases all the time.
Right. I think in this case it would have been known in the prison community. People talk a lot. This is a high-profile case nationwide.
Smaller community.
Absolutely. They're going to know this is the guy who testified, and hopefully he's okay after that. It is bold for him to testify, but the prosecution is using all this to show that this defendant admitted to it readily, not just once, not just because he was drunk once and slipped, but multiple times using the N-word, saying it in front of multiple people, if you believe this witness. So that's powerful testimony.
We're going to switch back to more testimony from Charlie Sturgill, the witness who was on the stand. We're going to listen to a little bit more of his testimony before we take another break. Back to our discussion of the Frankie Gebhardt murder case. We're going to continue our review of testimony from Charlie Sturgill in just a couple of minutes, but Dan Schorr is here with me first. So Dan, just to put this case in a big picture here, you've got a cold case that took 34 years for prosecutors to move forward, and I think one of the more interesting facets of it is the state got up there in front of jurors and said, we screwed this thing up collectively when different people were in charge 34 years ago. And that took some guts to just call that and tell jurors, hey, look, this was messed up for a long time. We're trying to make it right now.
Well, that's the first question with any cold case. Well, why now? Why not back then? And you have to give some explanation. Is it that new evidence surfaced, new technology like DNA enabled you to get new information? Or was it that law enforcement just did a terrible job back then? It's probably easier to say law enforcement messed up 35 years ago than it would have been saying they messed up 10 years ago, where a lot of the same people would still be their colleagues and working with them. I imagine the people 35 years ago are not still leading law enforcement, so it's a little easier to say, look, they messed up and things are different now, and this is why we're going forward.
It sort of added to the mystery of, you know, is this racial hatred, and did it permeate the whole area back then? You know, local jurors are drawn from local communities because they know that local community, and that's why there's a guarantee legally that one would be judged by a jury of one's peers from the district in which the crime was committed. So presumably, local jurors would kind of know what was going on in the community back then because they have some of the organic social history of that area ingrained in the knowledge they bring into the courtroom as well.
Right. So when they hear this law enforcement community 35 years ago did not take this murder investigation seriously, maybe that'll ring true to them, that they know, yeah, that's the world that was like that then. Hopefully it's better now. It certainly is better in the sense that they're bringing this case now way they didn't before. But the question that jurors are going to be wrestling with is, if he committed this murder with somebody else and he's been openly talking about it for a while to multiple people, why wasn't this brought earlier? And the prosecution needs to explain it, and this is part of that explanation, that law enforcement just didn't take it seriously. Evidence really wasn't collected, it wasn't pursued, and it was lost over time.
And that it took time to actually get the investigation rolling from the perspective of new blood coming into the law enforcement community there. We could get into big discussions about, you know, what happens when there's a case with a lot of publicity and then drawing an outside jury, and, you know, does that imperil the defendant, because it's the defendant's right to have a local jury. Sometimes these outside jurors, they don't know what was going on in that community, and that can be a detriment.
Right. It doesn't have to be a local jury. It has to be a jury of their peers. Usually that is a local jury, but we see times where, to avoid bias, juries are brought in from other places, so that's not out of the realm of normal. And this defendant, he's been in this community for a long time. Apparently, if you believe that last witness we saw, a lot of people in the community had heard him talk, or multiple people had heard him talk about committing this murder. So it might make sense to have people from another community hear this case. It's a difficult case because it's fraught with racial tension and the whole history of this area over the last 35 years.
We're going to continue our review now of testimony from Charlie Sturgill. He was one of the associates of the defendant in this case, and he testified to some crazy things that defendant said involving blood and recollecting, in this defendant's words, according to this witness, being involved in this crime. So let's listen to some more of Charlie Sturgill's testimony. That was the tail end of the testimony we are going to review today from Charlie Sturgill. He's talking about all these things that the defendant said. Frankie Gebhardt allegedly making up these stories about cutting off the victim's manhood, putting it in his mouth. And, is this just evidence that the defense is basically saying, hey, look, this guy makes up all kinds of stuff and he's just talking big and bad to make himself look like the guy in town that nobody wants to mess with, and there's really no truth behind it?
It could cut both ways. From the prosecution side, he's talking about this brutal killing and he's giving details that aren't accurate. Is he embellishing? Is he just forgetting what he did? He talked about being intoxicated a lot. The prosecution can say it's consistent with a brutal murder, even though the details aren't accurate. The defense, on the other hand, can say, look, he's just talking and saying ridiculous things that aren't true. So when he's talking about killing him, he's giving details that never happened. Obviously, you can't believe these rantings from him, and therefore he didn't commit the murder. So both sides have something to grab onto here and argue.
Yeah, okay, so that's one part of it, but what do we make of this other part of that clip that we just listened to where he basically says, this witness is saying that Frankie Gebhardt, the defendant, is basically threatening a black sheriff's deputy who was showing up to respond to a call. Does that ring as part of this? That African Americans, even those who were operating under the color of law enforcement, were afraid of this guy?
Right, and it shows that this defendant is a racist. It's really clear from him doing that, from the fact that he uses the N-word when he's talking to law enforcement. So he is a racist. Does that mean that he committed this racist murder? We don't know that just from that, but it is consistent, and it is part of the story that the prosecution is showing here, that this person for a long time has had these racial feelings, and that's consistent with the motivation that they say the killer had here. So that helps their case. It doesn't prove it in and of itself, but it's consistent.
The bottom line is it doesn't make this guy look good.
It doesn't make him look good, but also the bad thing that it says about him is consistent with the bad thing they're saying the murder had, which is being a racist. So it's consistent. So it's the same type of anger, bad motivation, sinisterness, and that helps the prosecution's case.
Yeah, we're going to continue with our review of testimony in this case. Terry Reed is one of the other witnesses who testified, and he basically said that he became friends with Frankie Gebhardt, this defendant, while they were incarcerated together. So let's listen to him. Okay, so that witness was incarcerated with the defendant, and while they were in jail together, they were watching TV news reports about the ongoing search at the defendant's residence. And apparently, Dan, the defendant turns to this guy and says, well, they're looking for DNA because I threw the knife in the well. And of course, authorities found a knife in a well, and they tried to turn around and use this conversation with this inmate to say that knife was the murder weapon.
Mm-hmm. Well, right. Yeah. How would he have known that the knife would be there if he didn't put it there?
Or if he threw it in the well and it wasn't connected to the crime, why would he tell the fellow inmate that?
Right, exactly. So, look, each of these things is a piece to the whole puzzle. Mm-hmm. The statements he's making, the racist comments he makes, other things that, the prosecution's bringing about, this is a complicated case made more difficult by the time that has passed. So each of these things is important, and that's another important piece to this.
Yeah, I mean, the thing that I can't get beyond is say, okay, look, well, even if we dismiss this as a jailhouse snitch who might be making things up, might be embellishing, might be lying, how would these guys have known about the knife before the authorities found it if this really didn't come out of the defendant's mouth?
Right.
This wasn't like a known piece of evidence, presumably back when the authorities were actually searching for it.
Right. It's a very specific piece of information. It's not just another person saying, oh, yeah, he said he committed a murder. It's specific details about a weapon that might have been used in that murder. So that is something that it's hard for the defense to explain. Why would someone who is this witness make that up? How would he know to make that up, even if he wanted to make that up? That's difficult.
You know, it seems credible to me, but the defense, of course, attacked this guy saying, hey, look, you have reason to embellish this. You have reason to make things up. You have reason to lie because you could get preferential treatment from the authorities for testifying against Frankie Gebhardt. They're the guys, or rather the state wants this guy. They botched the original case, and they have reason to think favorably upon people like you, Terry Reed, who have bad things to say about him. Here's the cross-examination.
No.
So here we have more witnesses basically drawing conspirators into this web. Dan, what do you make of this particular guy's testimony, you know, that William Moore and the defendant were involved in this crime? I mean, here we start to add more names into this scenario.
And that makes it even more shocking that there was no arrest for 35 years or 34 years, because multiple people are alleged to have been involved. And usually if multiple people are involved and know about it, then it's more likely that one of them will get into some trouble and flip on the other person, or they'll talk and it'll come forward. Is this just because law enforcement didn't take it seriously? Is it because that after the initial investigation it went dead for a long time? We don't know, but it's shocking and even more appalling that multiple people could have been involved in something like this.
This witness, Jonathan Bennett's up on the stand saying that some of this discussion didn't really happen until 3 or 4 years ago. So 30 years or so go by between the time of the murder and when apparently these discussions really start coming out into the open. Is it possible the defendant thought, well, you know, all this time has gone by, the evidence is in the bottom of the well, I can just start saying whatever I want because I don't think they can get me?
It's possible. If he made these statements, he felt emboldened to do it. He certainly didn't think that this would lead to him being arrested, charged, and tried for it. So did he think that so much time has passed? Was he older and maybe less careful about who he spoke to and what he said? He must have had the feeling, if he committed this murder, that he got away with it because 30-something years have passed. But fortunately, you have dedicated law enforcement people now who decided we're going to look at this, and I think the media had some role also in covering this and getting other people to come forward based on news reports. Yeah,
okay, so emboldened was a word that you used, and I think that also can be used to describe the defendant's own interrogation recordings. He's really combative with these officers, and one of the officers said, I thought he was going to jump across the table and hit me. I was afraid for my own safety during that interrogation.
Right, and as I said before, his language during the interrogation is graphic. He's using racist language while he's being questioned about a racist murder. So he's not cowering and trying to make himself appear to be this nice guy. He's really coming back at law enforcement, and that's shocking. And you can only imagine what he was like 35 years ago, how aggressive he was then if he did commit that murder, if that's what he's like now 35 years later.
All right, more testimony now from Jonathan Bennett, who is a witness in the cold case murder trial of Timothy Coggins. Timothy Coggins, the victim, of course. Frankie Gebhardt, the defendant, with accusations that Gebhardt murdered Coggins 34 years ago, and that it took all that time for prosecutors to build a legitimate case against this defendant. More evidence from the Frankie Gebhardt cold case murder trial in the community that's about a half an hour south of Atlanta, Georgia, where Timothy Coggins, an African-American man, was stabbed and then dragged to his death 34 years before this trial. A violent crime scene, and we're seeing that thread drawn back into the case again.
All right, this is a horrific murder. Putting aside who did it, this is a horrible, horrible death for this young man who 35 years ago was killed, and whoever killed him wasn't brought to justice. So they're bringing that out, they're giving the details, and those details plus the new statements allegedly made by this defendant and other witness testimony really paints a picture that the prosecution is trying to show that he is the killer here and he should be convicted.
Yeah, I can't help but look at this thing with a degree of sympathy for the family and everything. You know, waiting 34 years to see if the wheels of justice would eventually turn, and some of that was predicated on presumably, as the prosecutor said, the law enforcement community getting fresh blood with new perspectives and a willingness to take a case like this to trial after legitimately investigating it.
Right, and I believe the victims, I think it was his niece, she was talking about how the victim's parents were no longer alive and they couldn't see this day, but fortunately other people in the family are able to see this day where there's finally someone being brought to trial to face these charges, and hopefully, they want a conviction, obviously. But this has been a long time coming, and it was a cold case for a long time where nothing was being done to actively investigate it.
Yeah, exactly. And that's basically where we were left in this case. So I think we're taking a break next here on the Law&Crime Network. We're going to be back with more testimony in the Frankie Gebhardt cold case out of Georgia when we come back here on Law&Crime. And again, we have crime scene investigators, official witnesses back on the stand now, trying to connect dots from a case that happened some 34 years before this trial happened. Dan Schorr is here with me now, managing director at Kroll. He's also an attorney. So, look, again, we're back in the position of having the authorities try to describe to the jurors what this evidence from 34 years ago indicates, and this is digging through old files. This is trying to dredge up a lot of old stuff.
Right, so you have a member of law enforcement who is testifying about a crime scene that he was never at when it was an active crime scene. He reviewed all the evidence, he reviewed what the location is like now, but ideally in a murder case, you have someone from law enforcement who says, I was there, I saw the blood, I saw where the body was, I observed different evidence. You don't have that here, and that's a challenge because evidence has been lost. People don't have firsthand recollections of what the crime scene was really like at the time of the murder, but they're trying to piece that together and testify based on what they know now and what's still available now.
You know, let's talk about confrontation clause issues. Can they just get up there and say, well, this is what the file shows because the original investigator just isn't even, perhaps even around anymore, isn't even alive anymore, or does that raise a confrontation clause issue that the defense could raise?
It's interesting. You have possible hearsay issues there. Maybe you could get something in as a business records exception, but I think there's going to be problems if one of the things they're testifying to is a certain fact that only someone who is no longer around observed. So if they had someone who documented, I saw blood in X location, I don't think this person can get up and say there was blood in X location when he didn't observe it himself, or he can't say someone else testified to that. That would be a problem. But if he's piecing together the general layout of the crime scene, I think you can get away with that, and they are getting away with that.
That's really an interesting theory. You know, in these cold cases, a lot of times when we've seen them in the past, oftentimes that's what does happen. You know, I remember one case where there was a rehearing on a death penalty that we covered about a year ago here on Law&Crime, and the original witnesses to the crime were deceased. Or certainly were not available for testimony because they were old, they were literally like in the infirmary, they were not in any kind of mental shape to remember a case that they handled 30-some years ago, and there had to be people getting up on the stand and rereading their testimony, but in that case it was rereading testimony, not rereading from a record.
And I was going to say an exception to the confrontation clause is if there's been prior confrontation. So if someone is absent because of death or some other reason, you can say, well, they were confronted with cross-examination, and you can read back their testimony with a cross-examination. What you can't generally do there is just give their testimony. Let's say they testified in the grand jury and they're never cross-examined because the defense doesn't cross-examine someone in a grand jury. That testimony usually can't be brought out if someone died. But if they were in a prior hearing or prior trial actually cross-examined and then something happened so their testimony wasn't available live, you can usually bring it in that way.
Yeah, the bottom line is a case that's this old results in a lot of these evidence issues rearing their head more so than in a regular case because the state has to rely on a lot of very old records in order to try to make its case. And can the state bring all of the original investigators together to try to testify? Well, the state can certainly try. That assumes that those investigators are available, they're alive, assuming that they're well enough to be able to testify accurately about what happened. And this is the kind of case that tests the boundaries of bringing a case to trial 34 years after a crime was committed. Jared Coleman was one of the Bureau of Investigation witnesses who was on the stand in the Frankie Gebhardt case. Let's review a little bit more of his testimony. That's going to wrap up our review of testimony from Jared Coleman, a GBI special agent who investigated the cold case murder of victim Timothy Coggins. And here, Dan, we've had a discussion to say, hey, look, X amount was in the media, and that's just one letter of a huge alphabet of information that we knew about this case, and only the true killer would know the rest of this information. And a lot of that information is the information that Frankie Gebhardt, the defendant, was spewing about the community. How would he have known it? It wasn't public information back then.
Right, or if these other witnesses are making up that he was saying these things, how would they know what to fabricate? How would they know what specifics to give? That's not credible. So this really helps the prosecution's case. Also, you listen to that testimony, look how dogged they were about following up on this case. Even when they were discouraged by people that this can't be solved, they said, no, we're going to figure this out. And that's remarkable.
Yeah, we're going to come back with more testimony in the Frankie Gebhardt case when we come back here on Law and Crime.
Crime.
Heather Locklear case, we talked about it a little bit earlier. Dan Schorr is still with me now. Dan, not a surprise that somebody with deep pockets, a celebrity, is getting sued by an EMT who claims that she was combative after previous law enforcement accusations that she was combative.
Absolutely. Someone who's a celebrity, someone with deep pockets, that person is alleged to have assaulted somebody else, whether it's an EMT or someone else. There's going to be a civil suit. Might lead to a settlement. Unlikely it leads to trial. A lot of these cases go away with the payments. But look, we don't know what really happened there. If EMTs, they really do deal with dangerous situations, and this appears to be one of them, if what's the allegations are true.
Yeah, we're going to have to wait and see on that. In the meantime, we are talking about the Frankie Gebhardt cold case murder trial. We're going to listen to some testimony in a couple of minutes from the sister of the victim, rather. A horribly emotional case. 34 years this family lived with this crime before a trial happened.
Yeah, and it's good that justice is finally, that there's finally someone being brought to justice, or at least tried for these offenses after 34 years.
Yeah, Dan Schorr, I know that you have to run, so it's great to see you again here on Law and Crime.
It's always great talking with you, Aaron.
All right, as I said, we are going to listen to a little bit of testimony when we come back from another quick break here on Law and Crime from Talisa Coggins, the sister of victim Timothy Coggins. The state said he was stabbed and dragged behind a vehicle, and that Frankie Gebhardt was one of the people responsible. We will continue listening to that testimony when we come back in just a few moments here on Law and Crime.